Before we get to the callers, Rob, I want to take a minute out and have you run through for us what is the eviction process here in the state of Florida? And let's assume that we're evicting a tenant for non-payment of rent.
Okay, all eviction processes begin with the necessity of giving what's called a 3-day notice. This is Florida legislature's way of creating a safe port for tenants to get caught up on their rent before they are evicted and to give them proper notice and an ability to do that. So 3-day notices tell the tenant that they are how much rent is owed and where they can pay it, and that would get them back on board in terms of their rental arrangements. These are actually quite complicated because the Florida legislature and the Florida courts have added requirements to these that are easy for landlords to mess up at as they give 3-day notices, so they have to be very carefully done. A good example is if mail has to be used for the rent, then it has to turn into an extra 5 days, which becomes an 8-day notice. There are several other of those kind of pitfalls that can invalidate a 3-day notice. But assuming a 3-day notice is properly drafted and properly delivered, at the end of that period of time, if the tenant has not paid the amount that's put on that notice, the landlord is now in a position where they can bring forth an eviction action. It's important to understand the 3-day notice is not the eviction. It is the prerequisite to the eviction. Once that 3-day notice is expired, the landlord can file an eviction lawsuit. It has a 5-day return period, which is very short in Florida law, meaning that at the end of 5 days after they've been served, the tenant has to answer that lawsuit and put the rent into the court registry. Failure to do either of those things will result in a default of the tenant, which ultimately would lead to a writ of possession, which is the sort of the gold standard, what you are striving for when you are a landlord doing an eviction. When you get a writ of possession, that gets sent to the sheriff goes out to the premises and posts this writ of possession on the door, and what it tells the tenant is they have 24 hours to vacate. The sheriff then comes out there with the landlord at some prearranged time after the 24 hours. He keeps the peace while the landlord changes the locks, removes any remaining items, and effectively the law has now returned possession to the landlord.
Perfect, Rob. You know, back in the day that I did evictions, a lot of times the tenants would not serve an answer to the eviction process. Therefore, you would get a default judgment against the tenant. When you do get a default tenant, that eviction can happen as short as 15 days. That's
right. People often ask me, how long does it take to do an eviction? And I have to give them a kind of a parentheses type answer. It's very much dependent on what the tenant does. If he fails to give an answer, if he fails to put money in the court registry, this could happen as quickly as 2 weeks. That's the speed of light in law. But if they answer it, if they put money in the registry, you're now involved in much more conventional litigation that could take maybe 2-3 months to resolve.
And do you see non-lawyer landlords, laymen out there doing their own evictions, or are people generally, do they hire lawyers who do an eviction?
Okay, so I do see landlords trying to do this, and our listeners will be interested to know there is a package of forms that are sold at the court to help them do this. But what I see are landlords looking at these forms and having quizzical looks on their faces as to what they should be doing with these forms. And worse yet, I see landlords mishandling their cases, mishandling and misdrafting 3-day notices, getting their cases dismissed by the judge, who's very aware of what the requirements are, or the tenant's lawyer. And when that happens, not only do you have to start all over again, you are required to pay the tenant's attorney's fees. That is a painful conclusion. So I would say that unless it's something, if you're a landlord that's doing this on a one-time deal, you need an attorney to help you do it.
Thank you, Rob. We appreciate it. Yes, my guest today is Rob Solomon. He's an attorney in our office who does landlord tenant work.